earlier part of the lecture, we identified the aspects of what is the FTO search, the basis and the basics of the FTO search. In this lecture, we will focus on what are the strategies in relation to FTO search and what are the differences with respect to FTO vis-a-vis the other types of patent search. There are several strategies that can be based on the FTO's report that is prepared. An FTO search may provide you an option of the need for buying a patent or a licensing opportunity, so that you can also operate in the market segment. In areas where the implementation of the inventions are across platforms or the implementation of certain processes is across products, in that case it provides an important opportunity for cross licensing. It is also possible that the IP need to be pooled. For instance, in the electronic segment, there are a lot of patent pools. So, instead of paying for individual IP, you are pooling the IP together, so that a patent pool can be effectively a mechanism of a uniform licensing that can happen. So, rather than paying up the individual patentee, you actually pay to the patent pool. So, a scenario of a patent pool is also an opportunity that is created out of an FTO. Particularly, the FTO search will also help to design around to avoid infringement. So, one can actually look at inventing around or looking at what are the changes that can be done, what are the components that can be modified, what are the new components that can be added, what are the new steps that can be added to the process to avoid the infringement. Many a time the FTO report will also provide an opportunity to understand a later launch of a product. In this case, we are waiting for the patent expiry in that particular technology area. So, the company may actually now have adequate time to plan the launch of a product based on a patent expiry. So, therefore, looking at the patent maintenance status helps. In the case of pharmaceutical inventions and biopharma inventions, the patent term extension must be kept in mind. The other option that is available based on the FTO report is the case where you can also choose geographies which do not have the enforcement of the patent. So, if your report reveals that in certain countries there is that the patent is protected, you can avoid those geographies and market in those geographies where there is no patent right. When you see an opportunity in the market that you can actually make a good profit of the product, you can actually also plan for what we call an invalidation of the patent. So, in an FTO search, you are also actually assessing the patent strength of the competitor's patents. And if you find that the competitor's patent can be actually invalidated, one can choose the route of invalidation of a patent. So, that is one potential case that is available, or go ahead into the market and you can assert that there is non-infringement. So, that is one defense that one can take. It is at this stage one needs to keep in mind that today we are looking at technologies where no one is owning a given technology. There are multiple players in the market owning different sets of patents in relation to the same technology. This brings in an important question, that is it possible that they would be infringing each other's rights? Yes, that scenario could exist, because you are looking at technologies where each of them is actually holding a set of patents. And whenever you are looking at implementing patents in a particular product, there is a clear case of infringement that can potentially arise. So, often when you are looking at an FTO search, these considerations become a big consideration in terms of providing hindrance to the entire FTO search. It often becomes difficult to conduct an FTO search where you find nearby patents when there is close competition in a given area of technology. So, looking at which product, which patent becomes really very difficult in such a scenario. So, one should also therefore carefully choose the invalidation option, because it is possible that another case may be actually lined up against you. So, therefore, one has to really evaluate that option as well. Therefore, when one is conducting an FTO search, there are several considerations or points that need to be kept in mind. Since primarily the FTO search is centered around granted patents, the validity period of the patent should be checked. So, here you are looking at patent term restoration. Patent term extension is one thing which is kept in mind for pharma patents. Now, in many cases you can have expired patents. It does not necessarily mean that patents are available. It is possible that those patents may go into the restoration route. So, therefore, keeping track of that from the point of view of the real status of the patent is also important. Again, the question of challenges to patents, challenges to claims need to be considered. So, there could be re-exam requests being filed, in which case certain claims are already at the heart of the process of where the re-examination process has begun. So, understanding the validity of the IP in this case is again very important. Now, search for specific jurisdictions and markets where you are looking for the granted patents is an important consideration. Here at this stage, it is important to understand the technology space. So, a survey will reveal normally for those set of products what are the general geographies or the destinations. Now, understanding that is important to embark on the possible search for patents in those jurisdictions. So, it is never easy to conduct a FTO search, because it is possible that you may miss out certain countries. So, before even looking at looking at the country search with respect to the FTO, it is important to track product destination routes, so that you understand that most likely this is where the product is implemented, the product is actually brought into that particular market. Now, when you are looking particularly into processes, there is added difficulty, because the processes or components which are put into given product, it is much more difficult to search for those. So, therefore, the search that you do for a specific country, where you are looking at patents, is always tentative. So, it is important to keep reviewing the FTO search and have an iterative process of reviewing and searching once again. Though the FTO search is primarily about granted patents, it is often important that we look at published patent applications, because those again represent the stage of publication of patents, which are again very relevant. In many other jurisdictions, the question of non-publication request can actually delay the publication of patents. So, one needs to keep in mind the aspect of publication of patents also as a part of the FTO search. This is relevant also to now track the technology space. So, depending on whether the FTO is done at a very early phase or a later phase, some of these can become very imperative in terms of the search. In some sense, when you are doing an FTO search for an assignee becomes also useful, because the assignee may have different subsidiaries in different countries. the assignee may be bringing in different types of products into different countries. So, search by assignee, if you remember in the earlier lectures, in the simple aspects of search, we dealt with the aspects of number search, assignee search. It is here that you can find the relevance of the assignee search, that it tells you the spread of the assignee with respect to the different subsidiaries, the different holdings, and then the different technologies that they are bringing in the different geographies. So, while the FTO search is centered around looking at granted patents and patent information, the FTO search also reflects on a lot of general business information that you are actually cataloging. So, you are actually trying to understand where are the products of the competitor in the market and where is the competitor's business and business interests are. Another important aspect that we needs to keep in mind is the aspect of including the entire gamut of patents in an FTO search. This is often difficult because while you are doing a country based search in relation to the FTO, keeping in mind the PCT route is important. What are the newer patents being filed, inventions being filed for patents at the patent offices. So, tracking that brings in this consideration of looking at the entire search in relation to the entire patent data set. While prosecution history information is not so very important in this particular case, but however, when you are looking at related patent applications, that information is again important. And if the FTO search is coupled into an invalidation search, yes, prosecution history information becomes important. So, while the general FTO search is first planned, now while you do an FTO search, you get an idea about actually, you get important leads in relation to, well, this is some important information available in relation to a patent which may be necessary, which can be material for invalidation. So, and in many other instances, certain information becomes material such that there is space available for creation of IP. So, an FTO report is a very dynamic report to that extent, and an FTO report is actually a completely researched report providing you different levels of information, not just the patent data. Another important aspect is the ranking of patents. Now, we discussed the aspects of where technology space may be very closely represented by a diverse set of patents. There could be a patent thicket, in which case there could be technologies covered in those patents which are very close by. So, therefore, ranking of a patent data is important in order to look at which of the patents actually are that are relevant in relation to that particular product. Another aspect which an FTO search provides as an advantage is FTO search has to be done at every stage, that is during the planning, during the development and during the launch of a product. So, understanding the value of an FTO search is very important from the point of view of the role of a patent searcher. So, for a company which is in the early stage of manufacturing of a particular product or bringing in a process in relation to manufacturing a particular product, the need for an FTO search at a very early stage should be realized, and this is what is the importance of an FTO search. This would mean that the company is involving a best practice of looking at an FTO at the very early stage of the manufacturing of a product and not waiting till the product is made, and during the launch of a product there are risks in relation to patents. So, in such a case the FTO search is routinely done at every stage of one, as we discussed, the planning, the product development and the different stages of the product launch itself. So, the entire life cycle to that extent. There are certain important things which an attorney needs to keep in mind when you are doing an FTO search. Whenever there is a FTO search done in an early phase of where the manufacturing is being planned, an attorney will come up with the information in the form of an FTO opinion. It is at this stage an attorney will need to sit with the technical team to assess whether there is space available in relation to the manufacturing, what are the risks at hand, how long is the manufacturing planned so that the product can be launched into the market without the infringement of IP. So, the technical assessment becomes an important stage. So, an FTO search would naturally enlarge into what we call the technical assessment or the feasible assessment of that particular technology. So, often attorneys sit with technical teams to discuss, and the technical team gets the input and provides the information in relation to what are the aspects of the product that are being planned in relation to the development and manufacturing of that particular product. So, a detailed FTO opinion is a imperative to avoid litigation. So, how detailed should be the report? It all depends on the number of patents available. It also depends on the area. If the area is a high technology segment covered closely by a lot of technologies in the form of patents, then a detailed report is necessary. Not only in the case of a product launch, in the early phase of the FTO where the company is looking at an option of manufacturing a particular product, even there also you need a detailed FTO report. And why is that so? Because essentially the FTO report is all about risk mitigation, and so therefore one needs to keep that particular aspect in mind. So, doing the FTO at the right stage is important. What is also important is reviewing it at appropriate times. Keeping this in mind, we also need to understand today the difference between freedom to operate and freedom to action. In the earlier part of this lecture, we discussed about the aspect where there are multiple players in the segment and patents are owned by different enterprises. So, actually there could be no freedom to operate in each of the cases. Every company will come across a scenario where there will be no freedom to operate. What to do then? But products will be planned. This is the stage at which we are looking at what we call the freedom to action. That is, a company is well aware that bringing the product into the market will necessarily lead to IP infringement, but still the product needs to be brought into the market. And it is at this stage where you are looking at what should be the kind of partnerships that would be developed, how to effectively cross license the IP, how to ensure that the route of licensing works well for all the players in the market. And this is particularly relevant for those technologies which are highly complex, for technologies which are where there is a lot of interoperability that exists. So, today often the term of freedom to action is also being used to as a kind of an alternative, or rather beyond the freedom to operate, because yes, in certain cases there is no freedom to operate, but then there should be an option of a level playing field for all players in the market. So, there are opportunities coming up in that. So, the nature of the industry becomes an important consideration. What kind of technology partnerships can be taken up? A lot of discussion happens. For instance, a very recent scenario of medical devices was being discussed, where the case of a freedom of action is being planned. Also, today a lot of technologies have open source used as the important starting point for the developing of IP. So, there is part open source and then there is IP derived out of open source. There are open innovation platforms that are being also used to generate IP. Therefore, as we move into the complexity of open source vis-a-vis open innovation, the nature of how we will be looking at FTO reports is bound to vary. Often the FTO searches move into what we call larger aspects of search, patent search. So, it is possible that there is coupling of FTO searches with other types of patent search. When an early stage of FTO is taken into consideration, where you are looking at during manufacturing and you identify that yes, there is freedom to operate, there you are potentially looking at filing of IP, in which case one actually plans for the search in relation to where you are looking at the need for understanding novelty, all of that. So, one can actually look at that option. Now, an FTO search may reveal that there is no freedom to operate, in which case if you think that you can actually replace the market, and in the case where the patent is not so strong of the competitor, you can actually plan for a invalidation, in which case the FTO search will be coupled with an invalidation search. In the earlier lectures, we discussed the aspects of invalidation search. So, that can be now coupled with the FTO search to look at which claims to be invalidating and what set of patents to be invalidating with respect to the competitor. Sometimes the FTO search may also lead you to doing a patent landscape search. So, for instance, in the early aspects of the FTO search, if you realize that there is some space in this area of technology where you can actually bring in a product, you may want to assess your invention, a future invention, in the entire technology space. Where does it actually fit in which case you would undertake what we call the patent landscape search, which will be an elaborate search in relation to listing out the entire set of patents in a given area. So, it provides you what we call technology trends in relation to that particular area. And how does this help? It helps to actually provide you the gaps that are available between patents. So, one can actually embark on R&D. So, an FTO search can be coupled well with a patent landscape search, and so today FTO searches can mean quite elaborate and extensive searches in relation to the practice. As we now realize, there are several advantages of FTO search. Let us look at some of those. Primarily, it reduces litigation cost, so that an early opinion is sought on the options that are available. The other aspect is one can actually plan product launches depending on the patent expiry, and this is particularly very relevant in many areas of technology, including the pharma. Potential licensing options can be actually taken up based on the FTO opinion. Who are the people who could be the provide you investment in relation to the IP? Understanding of that can be realized from the point of view of the FTO report. It is also possible that you may be operating in a small space of that particular technology, which may be of value to the competitor. In that case, you may actually look at selling away your technology to the competitor. So, that assessment also can be done in terms of who are the ones who want to purchase this particular technology. FTO becomes a very, very important option for those involved in R&D, so that the R&D can be oriented to specific areas. Today, enterprises are investing a lot of money and effort in order to create products and processes of value. It is not always a pleasant thing to note that one is working on technologies which are no longer novel, which are no longer of value to the market. So therefore, in all those segments where products are being brought in, where innovations are being planned by companies to bring in products into the market, so in all those segments, it is important for an R&D to keep in mind that a regular FTO search will be helpful in order to steer the R&D in relation to specific technology areas. A search for patents may also help the industry to use what we call the safe harbor option. That is, now that the patents are expired or no longer valid, the industry can actually operate in that particular segment. So this is how one can actually utilize the option of where there are expired patents and actually can bring in products into the market. There are limitations of FTO search. As we had discussed earlier, no FTO search can give you 100% clearance. There are several limitations. One is that there are language barriers which can actually prevent the accurate evaluation of a particular patent. Certain patents are not published in regular times at a patent office, in which case that information is not available. Some of the documentation that is available at the patent offices may not provide you the full description of the invention, in which case again the question of mapping becomes a difficulty. Keeping track of the entry into the national phase of PCT applications can be quite an arduous task, particularly if there are many geographies that are involved. We discussed the aspects of complex technologies, where the product may have an integration of many different technologies, which means patents belonging to either one technology as patent sets, or patents can actually belong to different technologies. So doing an FTO search would mean a real elaborate assessment of those patents and the link with respect to the product. Sometimes identifying potential competitors may be very difficult, because the information in relation to a business entity may not be actually provided in the public listing. So that information may not be available. Another important limitation is the difficulty in identifying patent equivalents in different jurisdictions, which can materially affect the process of the mapping of the product to the patents. So keeping in mind these limitations are important when you embark on a FTO search. There are differences between the FTO search and patentability search, because essentially if you look at it from the point of view of prior art considerations, in the case of FTO it is granted patents. The scope of the search also is obviously different in relation to FTO, where you are really looking at the patent claims in this case in the FTO, whereas in the case of a patentability search, one is essentially looking at evaluating an invention for the purposes of novelty, non-obviousness. So in the case of a patentability search, the issue is all about whether an invention will be allowed under a particular law, whether the patent office will allow it as a patent. In the case of an FTO analysis, is typically a case of a risk analysis, the risk of infringing on an existing IP. The FTO search is typically a broader search, unlike the patentability search, because it takes into consideration factors much beyond the identification of patents. So, we discussed about the need to understand business information, the need to understand other data in relation to FTO. So, therefore, there are differences essentially between the FTO and the patentability search. So, in summary, if you have a patent, it does not mean that you will have the right to use, because it is possible that when you are bringing the product into the market, there could be other patents which would be infringing on. So, conducting an FTO search will help minimize the risk of infringing of the IP. Usually, the FTO search is done in relation to granted patents. However, when you are looking at FTO at an early stage of product development, it could mean even beyond patents which are necessary to search. So, those considerations will differ. Understanding the search by assignee is a good option to look at the strength of a technology of a competitor. The FTO search will vary with respect to the objective of the search and also with the particular technology in focus. The references for this lecture are from the patent search workbook developed by the course instructor and patent search tools and techniques by David Hunt. Thank you.